In 2015, Raphael Tuju set out to build a real estate empire in the affluent suburb of Kenyan. His company, Dari Limited, planned to construct luxury bungalows and acquire a historic 94-year-old estate. To fund this, Dari Limited signed a facility agreement with the East African Development Bank. They secured a loan of $9.1 million, roughly 943 million Kenyan shillings at the time. This chart shows the mechanics of that loan. The bank transferred the $9.1 million to Dari Limited, but required collateral in return. Collateral is an asset that a lender accepts as security for a loan. In this case, the agreement legally tied the prime Kenyan property deeds directly to the bank. The bank required even more security. Tuju and his children signed personal guarantees. A personal guarantee is a legal promise made by an individual to repay a business's debt if the company defaults. By signing, the Tuju family made themselves personally liable for the corporate borrowing. And high-stakes commercial finance, signing a facility agreement with personal guarantees, strips away the protective shell of a corporation. It places your family's generational wealth directly on the firing line if the deal goes south. By mid-2016, construction of the luxury homes fell behind schedule. The ambitious development stalled, and the relationship between the borrower and the bank completely fractured. The East African Development Bank maintains a very straightforward position. Dari Limited simply defaulted on their agreed repayment schedule, ignoring multiple demand notices issued in 2017. Tuju presents a sharply different account. He argues the bank engineered the default themselves by withholding 294 million shillings that was specifically earmarked for the construction of the luxury homes, breaching the original loan agreement. The dispute deepened when an official from the East African Development Bank formally recanted part of his own evidence, withdrawing statements he had initially sworn to in a court affidavit. What began as a standard commercial disagreement over a construction schedule rapidly escalated into a toxic zero-sum war for financial survival between a prominent political figure and a powerful regional lender. The original loan agreement contained a strict jurisdiction clause, dictating that any dispute had to be resolved under English law. This forced the initial legal battle to take place over 4,000 miles away in England. On June 19, 2019, the UK court delivered its ruling. The judge ordered Tuju and his co-guarantors to pay the bank $15.1 million, a figure that included the principal loan amount plus heavily accrued interest and penalties. Armed with the London ruling, the bank brought the fight to Kenya. The Nairobi High Court formally recognized and registered the foreign judgment in 2020. Tuju appealed the decision repeatedly, but the judgment was upheld to the Kenyan Supreme Court by 2023. By 2026, as auctioneers prepared to sell the properties, Tuju filed a fresh lawsuit to block them. High Court Justice Josephine Mangari struck the case down immediately, citing a legal principle called Res Judicata. Res Judicata translates to a matter judged. It is a legal doctrine meaning that once a competent court has finally determined an issue between two parties, the exact same dispute cannot be endlessly relitigated just because the losing side is unhappy with the outcome. By exhausting every level of the judicial hierarchy over 7 years, the debtors ran out of legal runway. The protective shield of the courts was completely stripped away, leaving the auctioneers free to act. The legal defeat quickly translated into physical reality. On March 14, 2026, at 3 a.m, an estimated 50 police officers in unmarked vehicles descended on the Dari Business Park in Kenyan. The officers forced their way into the compound, ordering Tuju, his guards, and restaurant staff to immediately vacate the premises. According to Tuju, the officers executing the midnight operation refused to produce any valid court order authorizing an eviction. This action directly confronts Article 40 of the Kenyan Constitution. That article explicitly protects citizens from being arbitrarily deprived of their property, ensuring that asset seizures follow strict, transparent legal protocols. It also challenges Article 47, which guarantees every person the right to administrative action that is expeditious, efficient, lawful, reasonable, and procedurally fair. Midnight raids executed by officers in unmarked cars do not meet that constitutional standard. When the sun rose on March 14th, the precedent was set. Even in the presence of the Constitution, massive commercial debt can be used as the justification for 50 officers to enter your home at 3 a.m. without a warrant. Following the raid, Tuju launched a severe counteroffensive. He filed a formal criminal complaint with the Directorate of Criminal Investigations, accusing senior counsel Fred Ojiambo, the bank's lawyer, of fabricating evidence and submitting forged affidavits to the courts. Tuju escalated the matter to the very top, delivering a formal petition to Chief Justice Martha Koome, alleging widespread corruption and claiming a commercial court judge demanded a 10 million shilling bribe for a favorable ruling. These explosive accusations sparked immediate public outcry. Prominent political figures and citizens began questioning whether state security forces were being unlawfully weaponized to execute private debt collection for a foreign bank. Violent midnight evictions and accusations of multi-million shilling bribes forced the public to ask a difficult question. In high-stakes commercial disputes, is justice strictly based on the law, or is it simply sold to the highest bidder? Despite the outcry, the reality remains grim. With the interim injunctions lifted, Garam auctioneers are moving forward. The East African Development Bank has already successfully auctioned off one of the linked properties situated along Gong Road. While Tuju continues to fight the process in the Court of Appeal, the legal protections have worn incredibly thin. The auctioneer's hammer is actively hovering over his remaining billion-shilling assets in Karen. The fine print of a facility agreement is a set of legal piers. Once they're in motion, they can grind through a business, a family's wealth, and the very constitutional rights meant to protect them.